So more than anything, we just kind of wanted to give you some things to consider if maybe you were looking to implement a process where you could get reimbursed for some of the third-party fees you've incurred with processing loan applications, or maybe it's something you're already doing and you can look at, okay, are we all on the same page here? And the concerns we're going to talk about, they're not all regulatory. And so first, we are going to look at those regulatory prohibitions, and those are just going to be on consumer purpose loans. And so first off, I think the one that we're all probably familiar with is on consumer closed-end real estate secured, your TRID covered applications. You cannot charge an applicant beyond the cost of a credit report until the applicant has received that loan estimate and indicated an intent to proceed. There's also a prohibition when it comes to HELOCs, which probably doesn't get talked about as much. But on a HELOC application, we of course have that program disclosure, that initial application disclosure, and the brochure. So once those are received, you can collect a fee, but the applicant has 3 days to essentially review that information and say, hey, I don't want it. And then any fees that you may have charged do need to be refunded. And the same would go in the case of, hey, you gave that initial application program disclosure, and then maybe something changed from it. And the applicant said, I don't want to go forward with this. What you told me has changed. Again, you would need to refund fees. And there's just a couple exceptions when it comes to that, such as if on a variable rate plan, if the rate has obviously changed, or if you estimated those third-party fees in good faith, but something changed. The kind of strange thing to consider here is that if we go all the way through a loan application process and get to closing and rescission is involved, there's more work for the financial institution generally, but there's also more protections for your applicant or borrower in that case. In that case, if someone would be rescinding the loan, then everything would need to be refunded. The other thing that you want to keep in mind here is from a fair lending standpoint. A lot of times I feel like sometimes we go into this with maybe kind of an emotional reason, like maybe you worked a long time on an application and you thought, wow, we really worked hard to get this done. We incurred all these fees and now they're walking, or maybe they're going to a competitor. And so those are the instances that say, hey, we want to charge them. And not to say you can't in those instances, as long as you're following, the regulatory prohibitions, but I would say that from a fair lending standpoint, you're going to increase your risk. And so from a technical regulatory standpoint, those are really the prohibitions. But I want to make it clear that just because you are able to charge an applicant a fee doesn't mean that the applicant is legally obligated to you to pay the fee. The legal obligation on behalf of the applicant would be a different story. And that's really where most of the considerations come into play. And some additional things to consider. Well, we can't give legal advice. And I always tell people you wouldn't want my legal advice anyway. But if you're going to have something that you're going to have the applicant on the hook for some of these fees, I'm assuming that there needed to have been some agreement in place between you and the applicant. And that if that is the case, you're going to want to have it reviewed by legal counsel to make sure that the verbiage on there is appropriate to actually make them liable. And then another question that comes up is, when are we going to provide it? Obviously, there's concerns that it's not the most customer friendly to spring it on the applicant early in the process, but your chances of success if, okay, I call to withdraw, and then you're like, oh, we're going to have you sign this, so you have to pay us all these fees, your success rate probably isn't going to be very good there. The other thing is to consider, are you concerned about getting reimbursed for all fees? Or is it just for certain services? Like the appraisal can usually be, one of the higher costs. And so maybe that's what you're concerned about. And then follow up. Some of your applicants might pay, reimburse you first request, but not all will. And so you need to consider what kind of time and resources you want to devote to the follow-up. And again, you're going to want to be consistent. So while there are plenty of compliance considerations, there are plenty of other things to consider, and we would encourage you to consider these items and just to, if you're looking to do this, maybe work to build an overall consistent process rather than trying to implement it on more of a one-off, because I think you'll find lower risks from a fair lending standpoint. You'll meet your compliance obligations, and then you'll just have a more successful process more than likely as well.